Welcome, everybody. Welcome to another episode of The Law of Self-Defense, Sunday evening edition. And we are here to talk about crazy judges. Again, crazy judges, this time defending arguably the most violent gangs in America today. Tren de Aragua. Aragua. Is that how Trump would say it? Tren de Aragua. So we're going to jump into it. Fair warning, this is not going to be a short show. We have a lot of stuff to cover here. I have a long list of topics to work through because I try to give you guys the real deal broken down into plain English. This, of course, all involves the federal judge who on Friday announced that he was going to put an injunction on Trump's executive order invoking the Alien Enemies Act for the purpose of summarily deporting gang members of TDA. We'll talk about that a bit. Some people mistakenly believe that the Alien Enemies Act, some even smart people, can only be invoked during wartime. I'll explain why that's not true. I covered the executive order in detail on Friday, but we'll give it a quick look tonight just to refresh everybody's recollection. Of course, the Alien Enemies Act is from 1798, but it has been used within the lifetimes of Americans living today. 1948 was the most recent time it was tested at the Supreme Court and found to be constitutional and beyond review by the courts. Then we'll take a look at this federal judge's injunction. It's really just a paragraph long. We'll take a look at the Democrat response. The Democrats are all for helping out TDA. They are 100% behind it. A little bit about who this judge is. This judge has an interesting history. Then we'll take a look at some El Salvador prison footage, because it turns out, despite this injunction, over 200 TDA guys got delivered to those El Salvador prisons. They even El Salvador produced some, like a little 3-minute, almost like a trailer of their arrival at the prison. It's great. We'll watch that. And then we'll get to the White House response. So the White House filed a response the same day, yesterday, as this injunction, but they filed a more detailed response, including now Pam Bondi, who was not kind of on the emergency response this morning. So that's the one we'll go over. And finally, the promise of the show, how to fire these judges without having to go through the process, pain, the burden of impeachment under the U.S. Constitution. Everybody ready? All right, so let's dive in. Where did I put my stuff? Hold on. Oh, for heaven's sakes. Let's see. Nothing but the finest production values here at Law of Self-Defense. All right, here we go. Join me for a deep dive. I got to pin something. I almost forgot. Shane has to put in the subscribe notice. Put that in, Shane. I'll try to remember how to pin it. So join me tonight. Join me this evening, Sunday evening, for a deep dive into the explosive events unfolding since Friday, March 14th, only 2 days ago, when President Donald Trump invoked the Alien Enemies Act of 1798 with a bold executive order targeting the Venezuelan gang Tren de Aragua. Tren de Aragua. First signed into law by America's second president, John Adams, the Alien Enemies Act grants the president sweeping powers to detain and deport enemy aliens with minimal court oversight. Some would say no court oversight. But the plot thickens because one day after this executive order, a D.C. Circuit judge, Judge James Boasberg, issued a summary injunction freezing the executive order, halting the deportations, shielding violent gang members. In fact, TDA prisoners who were already en route to deportation in the air, this judge ordered those flights to turn back, turn those planes around. White House said this unelected, black-robed, inferior trial court judge of the Article 3 judicial branch. Got news, though. The planes didn't turn around. The planes landed in El Salvador, friendly El Salvador to the U.S. They have a very U.S.-friendly president. And it turns out they're happy to accept all the TDA people that we're willing to send them. It's a very happy deal the U.S. has made with El Salvador for both of us, less so for TDA. So after this injunction, the White House fired back against Judge Boasberg's injunction with an appeal that very night, and then this morning an updated appeal to the Court of Appeals asking for a stay or a freezing of this injunction. So a whole bunch of stuff to cover with all of you. All of this, not going to be a short show, but hopefully it will be fun. It's certainly going to be fun for me. All right, first let's talk about this notion. Oh, before we do that, before we jump into the meat of things, I do have to remind all of you to subscribe. Folks, the best thing you can do for this channel. Let's see. I'm looking for Shane. There you go. Pin it by clicking on the... Let's see. I don't see it, Shane. I don't see a subscribe post. Maybe do it again. All right. So the best thing you can do for this channel, if you like this content, is to hit that like, thumbs up button. And oh, there it is. Okay. Let me see if I can do that. Hit this pin message. All right. It's pinned. Best thing you can do for this channel. Hit that thumbs up like button, hit that subscribe button. We just hit, I think we hit, have we hit 165,000 subscribers? It looks like we're at 164,600. 164,600. Check that out. 609. It would be great to hit 165 tonight, folks. We only need, what, 391 more subscribers to hit 165. My goal is 1 million. 1 million subscribers for this channel. You can help me achieve that by hitting that subscribe button yourself. That's what tells the YouTube algorithm, the like and subscribe buttons, to share our content more broadly on the platform. And that's, of course, what we're trying to do, is grow the law of self-defense community. Also, we have a sponsor of today's show. That is my good friends over at CCW Safe, providers of legal service memberships. What many people mistakenly call self-defense insurance. In effect, they promise to pay their members' legal expenses if the members involved in a use of force event. Of all the offerings out there for this kind of thing, some of which are horrifically bad, CCW Safe is my choice. I am personally a member. I trust them. If you'd like to know why I trust them, I have a little video at lawofselfdefense.com/trust that explains why they're my choice, the best fit for me, and perhaps the best fit for you. And at that same URL, you can find a 10% discount code for when you join me as a member of CCW Safe at lawofselfdefense.com/trust. All right. Where does that bring us now? I'm going to move that over here. Close this. Okay. A lot of people have been saying that this Alien Enemies Act can only be invoked during a time of war. I'm seeing that a lot on social media. Here's one example. This guy, Joshua Riddle, his brain is riddled. I think the Alien Enemies Act is intended for wartime use, and we're not at war with Venezuela. It's not permanent, meaning the injunction. He's basically just saying, hold up, let's make sure this is legal. I don't like it, but it's legal. Well, the Alien Enemies Act is not intended for war, but he's not the only person who mistakenly thinks so. Even some smart guys think so. Here's an article in Reason Magazine, an intellectual magazine on the right, by Ilya Soman, who is a smart guy. Ilya is a smart guy. I've not met him, but I've read a lot of his work. I've heard him testify before Congress. He's a very smart guy. But like a lot of the intellectuals on the right, he's lost his mind to TDS. I mean, just look at this. Trump invokes Alien Enemies Act as tool for deportation. Federal court issues temporary restraining order against it. If courts allow Trump to get away with using the act in peacetime, it would set a dangerous precedent because we're not at war, right? And this is only supposed to be for war. Is that what we're hearing? It's almost like these guys didn't bother actually reading the act, because here it is. Whenever there shall be a declared war between the United States and any foreign nation or government, so that's the war trigger, but there's a second trigger for the Alien Enemies Act. Whenever there shall be a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion shall be perpetrated, attempted, or threatened. It doesn't even have to be occurring. Threatened is enough. Against the territory of the United States by any foreign nation or government, that's the second trigger for the Alien Enemies Act. So, when Trump issued his executive order, his proclamation of invoking the Alien Enemies Act, what did he talk about? Well, he talked about exactly this. Exactly this. So here it is. Let's take a quick refresher. See if I can make this a little bit bigger. Even bigger. Is it still in frame? There we go. So this is the executive order issued Friday by President Trump. Invocation of the Alien Enemies Act regarding the invasion. That's the second trigger. Doesn't have to be war. Invasion of the United States by Tren de Aragua. And you may be thinking, yeah, but they're a gang, right? They're drug traffickers. They're not a government. Trump addresses that. He writes a proclamation. Tren de Aragua is a designated foreign terrorist organization with thousands of members, many of whom have unlawfully infiltrated the U.S. and are conducting irregular warfare and undertaking hostile actions against the U.S. Does anyone doubt that's true? I can tell you, I live in Denver. They are going through apartment complexes, basically taking them over with AR rifles in hand. They are they're crossing the border illegally, unlawfully infiltrating the United States, and they are conducting irregular warfare. They're armed for war and taking hostile actions against the United States in violation of our laws. TDA operates in conjunction with Cartel de los Solos, the Nicolas Maduro. So Nicolas Maduro is the nominal head of Venezuela, a nation state, a government. The Nicolas Maduro regime-sponsored narco-terrorism enterprise based in Venezuela and commits brutal crimes, including murders, kidnappings, extortion, and human drug and weapons trafficking. TDA has engaged in and continues to engage in mass illegal migration to the U.S. to further its objectives of harming U.S. citizens, undermining public safety, and supporting the Maduro regime's goal of destabilizing democratic nations in the Americas, including the U.S. What Trump is saying here is that TDA is acting as an agent of Maduro and the Venezuela government. It is effectively a government nation that is invading the United States. TDA is closely aligned with and indeed has infiltrated the Maduro regime, including its military and law enforcement apparatus. So there is no meaningful, substantial distinction between TDA and the Venezuelan government. Nicolas Maduro, who claims to act as Venezuela's president, little sarcasm there, and asserts control over the security forces and other authorities in Venezuela, also maintains close ties to regime-sponsored narco-terrorists. Maduro leads the regime-sponsored enterprise Cartel de los Solos, which coordinates with and relies on TDA and other organizations to carry out its objectives of using illegal narcotics as a weapon to flood the United States. In 2020, Maduro and other regime members were charged with narco-terrorism and other crimes in connection with this plot. I'll stop here with this because it's clear that Trump has made the proclamation, the finding, as the Article 2 executive branch president, elected by the whole of the people to carry out our political will, that TDA is effectively an operation of the Venezuelan government. And on this evidence, it seems incontestable that that's the case. So that's our refresher on the executive order. Now let's take a look at the last time this Alien Enemies Act was considered by the Supreme Court, considered in terms of its constitutionality. And it was not recently, but it was in 1798. It was 1948 in the Supreme Court decision of Ludek v. Watkins. This was a spoiler 5-4 Supreme Court decision affirming the constitutionality of the Alien Enemies Act within the lifetime of people still living, still alive in the United States today. The court wrote, basically summarizing the statutory form of the Alien Enemies Act. The Fifth Congress committed to the president these powers, committed to the second president of the United States, John Adams. Whenever there is a declared war between the U.S. and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the U.S. by any foreign nation or government, and the president makes public proclamation of that event, all natives, citizens, denizens, or subjects of the hostile nation or government, Venezuela, being of the age of 14 years and upward, who shall be within the U.S. and not actually naturalized, so not citizens, shall be liable to be apprehended, restrained, secured, and removed as alien enemies. The president is authorized in any such event by his proclamation to direct the conduct to be observed on the part of the United States. So this is saying the president, once he makes this declaration, Congress gave him the authority to grab and deport these guys at his pleasure. He will determine the policies to be followed in exercising these powers. Skipping ahead here, as Congress explicitly recognized in the recent Administrative Procedure Act, some statutes preclude judicial review. The Article 3 courts have limited power. They have the power assigned to them by Congress. And from time to time, Congress says this statute is beyond judicial review. They said that with respect to the Alien Enemy Act. This Supreme Court did. As Congress explicitly recognized, some statutes preclude judicial review, and the Alien Enemy Act of 1798 is such a statute. Its terms, purpose, and construction leave no doubt. The language employed by the Fifth Congress could hardly be made clearer or be rendered doubtful by the incomplete and not always dependable accounts we have of debates in the early years of Congress. The act concerning alien enemies, which confers on the president very great discretionary powers respecting their persons, appears to me, and this was Chief Justice Marshall writing in an earlier case, appears to me to be as unlimited as the legislature could make it. The very nature of the president's power to order the removal of all enemy aliens rejects the notion that courts may pass judgment upon the exercise of his discretion. Every judge before whom the question has since come has held the statute barred judicial review. We would so read the act if it came before us without the impressive gloss of history, just on its plain language, without having to know even the historical context. Continuing with Ludek v. Watkins, U.S. Supreme Court, still controlling law, very much controlling over this particular inferior trial court judge. Continuing, the power with which Congress vested the president had to be executed by him through others. He provided for the removal of such enemy aliens as were deemed by the Attorney General to be dangerous. But such a finding at the president's behest was likewise not to be subjected to the scrutiny of courts. For one thing, removal was contingent not upon finding that in fact an alien was dangerous. The president was careful to call for the removal of aliens deemed by the Attorney General to be dangerous. But the short answer is that the Attorney General was the president's voice and conscience. In other words, speaking with the Article 2 executive branch portion of the U.S. Constitution grants all executive authority of the United States to the unitary president, a president, and then he delegates that authority to his subordinates. When those subordinates are speaking with that authority, they are speaking with the voice of the president of the Article 2 executive branch. Continuing. And so we reach the claim that while the president had summary power under the act, maybe it did not survive cessation of actual hostilities. So this case involves a German national who was in the U.S. before World War II started, was still in the U.S. after World War II was won. Germany had collapsed. We didn't have a peace deal yet when this was going on. That was all still being negotiated. But the dissent in this case was arguing that, hey, the war's over. And the war was the basis for this application of the Alien Enemies Act, World War II. So now that the war is over, the act should no longer be in effect. The majority here says in the war context, well, is the war really over? Because we still have rent control. We still have a lot of wartime provisions that are in effect. This war language doesn't apply in our context this evening because President Trump did not use a war for his invocation of the Alien Enemies Act. He used the invasion and predatory incursion trigger to invoke the Alien Enemies Act. So I'm going to skip over all the war language here because it's not relevant to Trump's application of the act. But getting back to the act is almost as old as the Constitution itself. And it would savor of doctrinaire audacity now to find the statute offensive to some emanation of the Bill of Rights. In other words, the guys who wrote the Alien Enemies Act, they were the authors of the Bill of Rights, contemporaries, colleagues of the authors of the Bill of Rights. It would be outrageous to imagine that they wrote the Bill of Rights and then wrote the Alien Enemies Act to contravene the Bill of Rights. Continuing, the fact that hearings are utilized by the executive to secure an informed basis for the exercise of summary power does not argue the right of the courts to retry such hearings, nor bespeak denial of due process to withhold such power from the courts. That's another thing I keep hearing people say. Well, you can't use the Alien Enemies Act. I mean, everyone's entitled to due process of law, as if due process of law, by definition, was the longest, most complicated and involved process imaginable. Due process of law just means you get a process. A process. That's it. And Congress defines the process under particular circumstances. And the process for summary deportation under the Alien Enemies Act is that the president declares you an alien enemy. That's the due process. Continuing, such great war powers may be abused, no doubt, but that is a bad reason for having judges supervise or exercise whatever the legal formulas within which such supervision would nominally be confined. In relation to the distribution of constitutional powers among the three branches of the government. The optimistic 18th century language of Mr. Justice Iredell, speaking of this very act, the Alien Enemies Act, is still pertinent. And he wrote, all systems of government suppose they are to be administered by men of common sense and common honesty. In our country, as all ultimately depends on the voice of the people, they have it in their power, and it is to be presumed they generally will choose men of this description. But if they will not, the case, to be sure, is without remedy. If the people choose fools, they will have foolish laws. How about that? If they choose knaves, they will have knavish laws. But this can never be the case until they are generally fools or knaves themselves, which, thank God, is not likely ever to become the character of the American people. Man, he must be rolling in his grave. Back to the Supreme Court majority here. Accordingly, we hold that full responsibility for the just exercise of this great power, summary deportation under the Alien Enemies Act, may validly be left where the Congress has constitutionally placed it, on the President of the United States. Now, that's the whole majority opinion. I do want to read one paragraph from the dissent, because the dissent doesn't like this outcome, obviously. It was a 5-4 decision. The dissent says, listen, You should understand, everyone reading this should understand, this is what the majority is making the law. So they restate the majority's position, the restatement from the perspective of the dissent, right? They think it's wrong, but this is the dissent's understanding of the Alien Enemies Act under the Supreme Court holding. And this is written by Chief Justice Black, a famous Supreme Court justice. He writes in the dissent, the Supreme Court now holds, as the government argued, that because of a presidential proclamation, the enemy alien can be deported by the Attorney General's order without any judicial inquiry whatever into the truth of his allegations. The Supreme Court goes further and holds, as I understand its opinion, that the Attorney General can deport him whether he is dangerous or not. The effect of this holding is that any unnaturalized person, good or bad, loyal or disloyal to this country, if he was a citizen of Germany before coming here, can be summarily seized, interned, and deported from the United States by the Attorney General, and that no court of the U.S. has any power whatever to review, modify, vacate, reverse, or in any manner affect the Attorney General's deportation order. This is the current controlling law on the application of the Alien Enemies Act in America, folks. This is it. And this petty, little, inferior trial court judge in the D.C. Circuit, are we to pretend he doesn't know this? Are we to pretend that he read this and all the prior sections we read that said the courts have no role here, and said, you know what, I'm going to enjoin the President of the United States. That's what I'm going to do. And he didn't just enjoin it a little bit, he enjoined it a lot. Here is his minute order issued upon request by 5 TDA members. He wrote, this was yesterday, today, last updated, but it was yesterday, March 15th is when he first issued it. Minute order. So he gives them he gives TDA, every TDA gang member in America, he forms them into a class of people who are the target of this executive order. So his injunction applies to every TDA member in the country, every single one of them, even people, not just the 5 people appearing before him, everyone. And then he writes, the government, meaning the White House, the president, the Article 2 executive branch of government is being ordered about by this trial judge. The government is enjoined from removing members of such class, TDA, pursuant to the proclamation, the injunction, for 14 days or until further order of the court. He also ordered that anyone of these guys who was on a plane in flight on their way being deported, that the plane had to turn around and come back to the U.S. So that's what this judge thinks of himself. He thinks quite a bit of himself. And the Democrats are all for it. The Democrats are all for it. Here's a great article, an ex-post by Scott Jennings. If you don't follow Scott Jennings, he's on a lot of the left-wing news media. He's like the conservative, the token conservative guy on a lot of this media. And he writes here, prepare for the next 80-20 issue. The Dems are always jumping on the 20% portion of these 80-20 issues. Dems passionately arguing for the return of Venezuelan gang members to spite Trump. And what he's got here is this image on the right's a little video. I'm not going to play it, but it's TDA guys in Denver in an apartment complex with AR rifles, basically extorting every resident, saying you pay your rent to us now, is what's happening in that video. And the Dems are not doing well at the moment, betting on all these, on the 20% side of all these 80-20 bets. Here's current polling number, came out today. The positive, favorable rating for the Democrat Party right now is 27% of those polled. That's 12% below the Republicans. That's the lowest rating they've gotten in the 30 years this poll has been run. This is not a good place to be if you're a Democrat. It's a very good place for Democrats to be if you're MAGA. Certainly, imagine if MAGA had control of 2/3 of the Senate, then our discussion we're going to have a little later would be a bit different. A bit different for sure. And by the way, the trend is very, very bad for Democrats. So here's the trend. They're the red line. Well, the unfavorable rating for the Democrats is this orange line here. It's gone up 20 points. 20 points since the election. Well, since the inauguration on January 20th. The Democrats have managed, with all the attacks on Trump and his executive orders and Doge, the unfavorable rating for the Democrats has gone up 20 points in just a matter of weeks. That's not good either. But they're doubling down. This morning on the news programs, they had Congresswoman Jasmine Crockett from Texas. She's been become one of the leaders, the leading voices of the Democrat Party. Nothing could make me happier than Jasmine Crockett being a leading voice for the Democrat Party. She's opposed to any kind of expedited deportation of TDA gangsters. She thinks TDA needs a chance. They need as much due process as we could give them. This is the Democrats, again, betting on the 20% side of the 80-20 percentage. How do we know? Who's really defending? What rational person is defending TDA in America and arguing against expedited deportation? I did a couple polls before today's show. Here's one on YouTube. What do you think about Judge Boasberg's, that's the judge, summary injunction freezing Trump's alien enemies executive order? TDA gangs didn't do nada. They're perfectly innocent. So that one of you guys that there's that 1%er, I know it. 9% asking who elected this judge. 89% this judge needs to be fired. Don't worry, we're going to get to that. And I did a similar poll on Twitter with similar results, except almost 4% saying TDA didn't do nothing. 89.2% saying this judge needs to be fired. Defending TDA, maximizing the due process of these illegally invaded drug dealing, weapons trafficking, Venezuelan gangsters, I don't think is going to prove to be the winning bet in America. So who is this Judge Boasberg? Who is he? Because he's got a bit of a track record. He's been around a while. He's known, for example, because he is in the D.C. circuit, he's known for defending Washington, D.C. gun control laws. That's good, right? Mandates that owners take gun safety classes, be photographed and fingerprinted, because all the bad guys do all that stuff, right? The bad guys, it's like there's no gun crime in D.C. The guys committing the gun crime in D.C., they're taking gun safety classes, getting photographed and fingerprinted. These are just unconstitutional infringements of the Second Amendment rights of law-abiding people. And they have to re-register their weapons every 3 years. You got to go back into the cops and say, these are my guns. Why? Why? It's senseless. Utterly senseless. Clearly an infringement of the right to keep and bear arms. And inconsistent with Bruin. There was none of this existed at the founding. Nobody was taking gun safety classes. They were taught by their fathers. Nobody was being photographed and fingerprinted. Nobody had to register their guns every 3 years. These things are facially unconstitutional. It's grotesque. Not only that, but this judge was also involved in the persecution of Trump at various stages. Of course, the federal prosecutors have gone after Trump many times. This judge signed off on the FISA warrant during the Russiagate hoax, where Hillary Clinton agents came into court and lied in order to get a FISA warrant, eavesdropping warrant on Trump. This judge granted that warrant. And then when it was discovered that the people who swore under oath to him the conditions that justified the warrant, he didn't send that guy to prison for a day. Not one day. A slap on the wrist. For this guy lying to this judge, this court, to obtain a FISA warrant against the sitting president of the United States. Contemptible. Do we really need federal judges like this? That's who this guy is. So I mentioned earlier that one of the things he ordered was that, hey, TDA is now a protected class for purposes of my injunction, every TDA member in the country. And you're not allowed. I'm enjoining you from deporting them under this executive order. And by the way, if you have any of them on planes right now, flying out to be deported outside of U.S. airspace, I'm ordering you to tell those planes to turn around and come back. Well, that didn't happen. The turning around and coming back didn't happen. Here's a news report by Amuse, which is a pretty good account on X. I would encourage you to follow. And notes that 238 TDA members were sent to El Salvador, to their terrorism confinement center, which is not a very nice place. You've probably seen the photos of all the guys in white shorts and white t-shirts. Looks like underwear, basically, right? Fruit of the Loom underwear. Lined up, sitting on their butts on the ground, knees to back, knees to back, knees to back, rows and rows and rows of them. That's how El Salvador saved itself from its gang problems. It threw all these guys in prison. Well, El Salvador and the U.S. have come to an agreement a couple of months ago, maybe a month ago. Nayib Bukele, this guy, is the president of El Salvador. He's saving his country. He met with Marco Rubio, Secretary of State, about a month ago, and they had a very, very good meeting. And what they agreed to was that El Salvador would be happy to take any deportees from the U.S. that maybe need to be, detained in a high security prison for a while. Now, admittedly, they'll be detained at American cost. America will be paying El Salvador to hold these guys. But for America, the cost is extremely modest compared to what we pay to imprison people ourselves. And for El Salvador, it's pretty generous. So it's a win-win deal. Here, the president of El Salvador notes, I'll make this a little bigger. I guess I can't. Let's see, can I? Yeah, there we go. Today, the first 238 members of the Venezuelan criminal organization, TDA, arrived in El Salvador. They were immediately transferred to CICOT, the Terrorism Confinement Center, for a period of 1 year, renewable. It's like a 1 year subscription. I wonder if America got a discount for paying a year up front for each of these guys. The United States will pay a very low fee for them, but a high one for us. Over time, these actions, combined with the production already being generated by more than 40,000 inmates engaged in various workshops and labor under the Zero Idleness program, will help make our prison system self-sustainable. As of today, it costs $200 million per year. On this occasion, the U.S. has sent us 22 MS-13 members wanted by Salvadoran justice, including 2 ringleaders. One of them is a member of the criminal organization's highest structure. This will help us finalize intelligence gathering. I wonder how they're going to get intelligence out of these guys. This will help us finalize intelligence gathering and go after the last remnants of MS-13, including its former and new members, money, weapons, drugs, hideouts, collaborators, and sponsors. As always, we continue advancing in the fight against organized crime. By this time, we are also helping our allies, making our prison system self-sustainable and obtaining vital intelligence to make our country an even safer place, all in a single action. May God bless El Salvador, and may God bless the United States. Not only did they take them, but they made a movie about it. El Salvador made a movie of these guys arriving in the prison. See if I can make this bigger for everybody. Let's see, there we go. Now, it is 3 minutes, but I'm going to play it. I want to watch it again, and maybe you guys want to watch it. They even have some production value in here. They have some background music and stuff. This is what El Salvador's doing in partnership with the United States. Here we go. All right. Oh, yes. I know people will say I'm being mean because I lack sympathy for these guys. I do indeed lack sympathy for these guys. Zero sympathy at all. This is even better than keeping bad actors in Guantanamo. Guantanamo, it's outside the U.S. The due process is a little bit different, but they still were always finding a way to get lawyers in court. Now they can go argue in El Salvadoran courts for the release of these guys under this Judge James Boasberg's injunctions. See how much authority he attempts to exert in El Salvador. All right, folks, before I get to the Trump response to this injunction, which is what we'll cover next, I will look into questions and comments from all of you. If you're on YouTube and you want a question or comment for me to address, it does need to be a $5 super chat. If you're a Law of Self-Defense member, I'll just grab them from the member chat for free, of course, as usual. So I'll give all the... Oh, and please hit that like, thumbs up button. How many likes do we have? It's usually not enough. Well, it says 2. I guess I have to refresh the page. Hold on. Hopefully it's more than 2. All right. Half of you watching have hit the like, thumbs up button. Folks, it's free. It's free. Hit that subscribe button. If you like this content, why not subscribe? That's free too. And that thumbs up and that subscribe button is what tells the YouTube algorithm to share our content more broadly. That's what we need from all of you to help me. My goal is 1 million subscribers. 1 million. I can't do it without your help. I slave away in front of this webcam for all of you. All right. So let me take a look and see if there's any. I know I saw some super chats roll in, but I'll give you a chance to roll more of those in. I'll take a look at the member comments first. Let's see. Law Self-Defense member Phil says, if a circuit court judge is facing impeachment, can they preside over cases, especially ones for which they are being impeached? I would like to think that the Supreme Court would suspend their operation as a judge, but I have to confess, I don't know the procedure for that. I would expect that to be left largely to within the authority of the Article 3 branch, but there might be a statute on it. I mean, Congress can determine this. Congress determines what the courts are allowed to do. But if Congress has not, then I would expect the Article 3 judicial branch to manage it internally. And I don't know what those rules are for impeachment. Law Self-Defense member Phil says, got to be a special kind of stupid to issue an order that won't or can't be obeyed. Did the judge even bother to consider if the planes had enough fuel to turn around and return? No, of course he didn't. Of course he didn't. By the way, the White House representative he's speaking to in court doesn't know either. That lawyer, you think that lawyer knows how to get in touch with the plane? Of course not. I wouldn't know how to get in. No, none of us would. Kyle Cowden says, Trump and company have been playing nice far longer than I would have. It's time for him to say, sit down and shut up. Well, we may be getting close. Law Self-Defense member Phil says, of all the circuit court overreaches, it seems this one screams for Trump to simply say, your decision is in direct contradiction of SCOTUS established precedent and is therefore null and void. That would be nice. The controlling Supreme Court precedent is that this is non-reviewable by the courts, period. Law Self-Defense member Kent says, I couldn't find an email about this show. So folks, Law Self-Defense members, I'm not emailing the YouTube shows, the political analysis shows. I'm not sending emails out. If you want to be notified of those, you have to be subscribed to me on YouTube. YouTube will send the notifications. You will receive notifications for Law of Self-Defense members only streams and shows on the blog. But those are the use of force ones. Those are the shootings and the stabbings and the self-defense court decisions. The political analysis stuff like this is primarily YouTube. I just stream it as a courtesy on the member dashboard so you folks have an opportunity to ask your questions of me without having to pay the super chat fee. Uh, Law Self-Defense member Kyle says, for 10% off the incarceration of your terrorist, enter discount code LOSD10. Yeah, where were all the protesters while the terrorists were being deported? El Salvador seems to have that well in hand. Paul says, Gitmo is a country club compared to this. That wouldn't surprise me. Yeah, those guys did not look happy, right? The detainees, they didn't look so tough in those videos. I think they got a suboptimal future ahead of them in this facility. Law Self-Defense member Kyle says Dems are just handing hand grenades, political hand grenades, to their midterm challengers. I don't see how it could be any way else. It's unbelievable. Let's see. And Law Self-Defense member Johnny says, is there a pill to deal with the perpetual priapism? If this erection lasts more than 4 hours, you should call your doctor in El Salvador. All right. I'm going to take a look at super chats now. Let's see what we got. Oh, we got a bunch. Okay. Barry Soitoro, $5 super chat. He writes, Branca is in serious mode. It's Sunday and he's got a tie on. Thank you for what you do. Well, I love my work, Barry. Thank you for your support. Your people like you is what make it possible. And yes, we're doing legal analysis, so I'm wearing the tie. Michelle, $5 super chat says, what are your views on Lincoln's presidency? He pretty much railroaded over the Constitution, while maybe for good reasons. Yeah, I mean, it depends on, Lincoln fought to preserve the Union, in his view, not allow the Confederate States to leave. And he won. I'm pretty sure if you asked the Confederate States, they would have said, hey, we joined this Constitution voluntarily. And as far as we're concerned, we can voluntarily leave. It was never our understanding it was a one-way door. There's nothing in the Constitution that says if you join, you can't leave. So, I mean, I think it's now, of course, this all gets discolored by the issue of slavery and so forth. But from a purely political perspective, these independent territories joined the Union voluntarily. It wasn't right of conquest. And I'm sure they thought that they were privileged to leave if they wanted to. If they thought that, the other half of the Union had become overbearing and the partnership just wasn't working for them anymore. Irreconcilable differences. And they believed that hard enough to fight for it. Unfortunately for them, they lost. So it's how you feel about that political question is probably how you feel about Lincoln. Dapper Dave, 2021, $20 super chat. Well, thank you. That's very generous. Writes, the Trump administration should go to a district court judge in another state who's not a liberal nut. A lot of people are talking about Congress should simply dissolve the DC circuit. We don't have to have a DC circuit. Give that territory to one of the other circuits, the Fourth Circuit. There doesn't need to be a DC circuit. Remember, Article 3 of the Constitution, the judicial branch, establishes one court, the Supreme Court. All the lesser inferior courts, they're technically called the inferior courts. The federal trial courts, the federal courts of appeal, bankruptcy court, immigration court, tax court, federal court of claims. All of these are creations of Congress, not of the Constitution. Congress can create them. Congress can dissolve them. How many of these suits are coming through the DC circuit? The majority, certainly. Just dissolve the circuit. And then those judges don't have jobs. We'll talk in a moment about how to get rid of them without having to impeach them. Box Fort defendant. I forgot to grab this one. I saw it too. The president of El Salvador, when he saw a post on X about that the planes had to turn back, he posted, oops, too late. And the planes were already on the ground in El Salvador. That was pretty funny. Content of character, $5 super chat says, the most unsafe city places I've ever visited in the U.S., DC, Baltimore, Philadelphia, Memphis. I can't disagree with any of those. There's others that are very dangerous too, but those are definitely, they're absolutely in the top 10 for the top 10 for sure, and probably in the top 5. You couldn't pay me to go into Memphis. No way. John Q. Public, $5 says, but remember, we the American people have to prove ourselves to our public servants in order to keep and bear arms against these armed terrorists, right? This same judge who says, no, we have to give TDA gangsters, violent, gun, weapon, human trafficking gangsters, every benefit of the doubt in protecting their civil rights. But if you're an American gun owner, yeah, I'm going to vote in favor of those DC gun control laws. Even when that's a right protected, enumerated in the Bill of Rights as the Second Amendment. Not cool. Not cool at all. All right, those are all the super chats. Let's get to the White House response to this judge's crazy and apparently facially unconstitutional injunction based on controlling Supreme Court jurisprudence. So this is the emergency motion for a stay of this injunction that was filed this morning, Sunday morning. Hey, Stella, how you doing? Yeah, sure. You can DM me anytime. I will respond. See how big I can make this before it goes off the page. That fits, right? Okay. So this is Pam Bondi and a whole bunch of other guys at the White House. By the way, I recognize most of these names. These are really good lawyers. And it looks to me like the law is solidly on their side. So I think the White House is in a good spot here. The White House writes, the White House lawyers write, a few hours ago, a district court lacking jurisdiction. The first question every court's supposed to ask itself is, do I even have jurisdiction over this case? Do I have legal authority to decide this issue? And so the White House notes in the first, 4, 5, 6, 7, 8, 9 words, they're attacking the core authority of the judge in this manner. A few hours ago, a district court, federal trial court, lacking jurisdiction, issued an unprecedented nationwide temporary restraining order, which is supposed to be unappealable, but they're appealing it. Let's see, they're appealing it to the Court of Appeals. So they're not going right to the Supreme Court. A nationwide temporary restraining order purporting to halt the removal of aliens associated with TDA, a designated foreign terrorist organization, pursuant to both the president's constitutional authority to protect the nation and statutory authority under the Alien Enemies Act. A stay of this injunction pending appeal is manifestly warranted, as is an immediate administrative stay. So that's a stay of like the whole proceedings, not just the injunction. This Court of Appeals should halt this massive, unauthorized imposition on the executive's authority. So she's getting a second paragraph. Separation of powers doctrine violation. Court of Appeals. This unauthorized imposition on the executive's authority to remove people that the White House has determined, or the Attorney General, I guess, has determined to be members of TDA, a group the President and Secretary of State have found to be a threat to national security. This Court of Appeals should halt this unprecedented intrusion upon the executive's authority to remove dangerous aliens who pose grave threats to the American people. The trial court acted without any jurisdiction. These claims sound in habeas. That means these should be habeas corpus claims. You have the body, produce the body. This is where a court orders the government to produce in court someone they have under arrest and to justify why they have this person under arrest. Ludica v. Watkins, that's the case we just read from 1948, the Supreme Court case with the German national, where they said this is under the Alien Enemies Act, it's non-reviewable by the courts. See Ludica v. Williams, considering challenge to action under AEA as a habeas claim. AEA being Alien Enemies Act. Yet the plaintiffs here waived their habeas claims after the White House argued that only the Southern District of Texas, where the 5 guys who were suing here, 5 TDA members, not the ones who were sent to El Salvador. These are 5 different people. And they were being held in Texas. They waived their habeas claims after they argued that only the Southern District of Texas, where plaintiffs were held, had jurisdiction over their claims. We covered a case recently on this. Habeas corpus claims have been congressionally limited to the jurisdiction in which the person is being held. You have to go to that local court. This happened with Mahmoud Hamas Khalil, right? The guy grabbed at Columbia University for being the representative of a group that endorses terrorism. He was grabbed out of New York, Columbia University, and shipped right away to Louisiana. So that when his lawyers filed the habeas motion in New York, it was too late. He was already in Louisiana. And the law is that now his lawyers have to go to Louisiana, where he is, to file a habeas petition or produce the body petition. Continuing now with the White House motion here, the presidential actions at issue here are not subject to judicial review, as this court has squarely held. Accordingly, there was no lawful basis for this district court to enjoin the implementation of that executive order. And even if reviewable, the president's action is lawful and based upon a long history of using war authorities against organizations connected to foreign states and national security judgments which are not subject to judicial second guessing. I'm going to move a couple things over here. Let's see. Further underscoring the impropriety of this TRO, the 5 TDA members would not necessarily be irreparably injured by removal from the country, as the Supreme Court has expressly held. So there are conditions that have to be met to get a temporary restraining order. One of them is you're likely to win on the merits, which seems laughable here, given the law we just looked at in this show. The second is that if the action against you is not stopped, you'll suffer irreparable harm. But if they're deported from the country, they can always be brought back if it turns out the deportation was bad. So it's not irreparable. The White House continues, if this TRO were allowed to stand, trial courts would have license to enjoin virtually any urgent national security action upon bare receipt of a complaint. So this isn't like after a trial, folks. These 5 TDA guys got their lawyers in front of this judge, in front of James Boasberg, and he immediately just issued the injunction. There was no substantive argument here. Trial courts might next see fit to issue TROs restraining drone strikes, sensitive intelligence operations, or terrorist captures or extraditions. This Court of Appeals should stay this trial court's unprecedented order. Background: the Alien Enemies Act. We've already read it a few times. If there's war or there's an invasion or there's a predatory incursion, it triggers these expansive deportation powers of the president. Here they cite 50 USC 21. That's just the modern statutory language of the 1798 Alien Immigration Act. So they kind of chopped it up into specific modern statutes, but it's the same language. The White House argues the courts have recognized the legitimacy of the AEA as an exercise of the war power reserved to Congress and the executive. And no role for the judicial branch. The Supreme Court has observed that the AEA is as unlimited a grant of power as the legislator could make it. That's from Ludecky, which we just read. The Supreme Court has further explained that the statute encompasses matters of political judgment for which judges have neither technical competence nor official or constitutional responsibility. And this Court of Appeals has held that this statute confers unreviewable power in the president to restrain and to provide for the removal of alien enemies. The courts have therefore limited their review in prior challenges to very narrow questions there. The construction and validity of the statute, whether, when relevant, there is a declared war, and whether the person restrained is an enemy alien 14 years of age or older. So to the extent that there's judicial review, they can only ask one of two questions. If this person's being deported under the AEA because it was triggered by war, they can ask if there's a declared war taking place. They can also ask, hey, is this person actually 14 years old and designated an enemy alien? If the answer to both those questions is yes, in this case, of course, the trigger would be the alternative trigger of invasion or predatory incursion. Then that's it. The court has no other role. That's the due process. That's the entirety of the due process to which these designated alien enemies are entitled before being summarily deported. The president's proclamation. So this is the executive order. We already looked at that again, made findings that they're narco-terrorists, that they're associated with the illegitimate regime of Maduro in Venezuela. So they're a failed narco state. They're effectively agents of the Venezuelan government. Illegal mass migration to inflict harm. I don't want to read the whole executive order word for word again in this motion. So they've taken over great control of Venezuelan territory. Based on these findings, the president proclaimed that all Venezuelan citizens 14 years of age or older who are members of TDA are within the U.S. and are not actually citizens or lawful permanent residents are liable to be apprehended, restrained, secured, and removed as alien enemies. The president further directed that all such alien enemies are subject to immediate apprehension, detention, and removal. The Attorney General and the Secretary of Homeland Security have been tasked with executing these directives in addition to any separate authority to DHS has apprehend and remove such persons. The president has further issued regulations prohibiting the entry, attempted entry, or presence of the alien enemies, with any such alien enemy subject to summary apprehension. Apprehended alien enemies are subject to detention until their removal from the U.S., and they may be removed to any such location as may be directed by those responsible for executing the regulations, meaning El Salvador. Part 3, this lawsuit. On March 15th, 5 nationals. So this was yesterday, the day after the executive order. By the way, I don't know if anybody else is talking about this, but I have a strong suspicion that the timing of all this stuff within this very short time frame may have been orchestrated by the White House, because there's too many moving pieces. There's these 5 guys suddenly appearing, represented by counsel in federal court, the courtroom of James Boasberg. There's the 238 guys on, I believe it was on 2 planes, flown to El Salvador, all simultaneously. And only the day before was when Trump, who'd been talking about invoking the Alien Enemies Act since at least last October. Well, he only actually did it on Friday with the executive order. So I can't help but wonder if the White House had scheduled the flights, of the 238 to El Salvador for yesterday, scheduled the executive order for Friday, and then somebody tipped off these 5 TDA guys that, hey, make sure you have your lawyers lined up to go to court quick because something's coming down that's going to concern you. Because the combination of these events is very favorable to Trump, even despite the strength of the law on his side. The political imagery of this judge ordering that 238 violent, tatted up TDA gang members have to be returned to the United States, brought back into U.S. territory, lawfully this time. Those optics are horrific for the left. So on March 15th, so I can't help but wonder if it was all orchestrated by the White House. That would be very clever. That would be very 4D chess. On March 15, 2025, 5 nationals of Venezuela who claim to fear removal, they're not removed yet, under the proclamation filed this class action complaint and a petition for a writ of habeas corpus with a motion for a TRO against the White House. In their complaint, they allege, among other things, that the White House actions are contrary to the Alien Enemies Act and the Immigration and Nationality Act. Hours after the complaint was filed, without the actual proclamation and without hearing from the White House, the trial court granted the plaintiffs TRO and ordered that the White House shall not remove any of the individual plaintiffs from the United States for 14 days. That's the TRO. A short time later, the court set a hearing on their motion, the TDA guys' motion, for a class certification for the same day, March 15th at 5 p.m. The government appealed the trial court's first TRO and filed an emergency motion to stay. That was filed yesterday. That's the one I'm not going to read here. A few hours after the government appealed, the trial court held a hearing on the motion for class certification, during which the 5 TDA guys dismissed their habeas claims at the trial court's suggestion. Oh my God. So this judge told them, listen, if you insist on your habeas corpus claim, I'm going to have to send this case out of my courtroom. I'm going to have to send it to Texas. Are you sure you want to do that? Wouldn't you rather have a DC federal trial judge handling this than a Texas federal trial judge? And the defendant said, you know what, Your Honor? We would. We would much rather have a DC federal trial judge handling this matter. So they waived their habeas motion so they wouldn't be sent back to Texas. So the matter wouldn't be sent back to Texas. And it was the judge who suggested that strategy to them. So the first TRO was heard ex parte. I think at the second one, the 5 p.m. meeting where they did the class designation, I think there was a White House representative there. But how much time would they have had to prepare? By the way, the fact that they filed like a 30-page response that evening, and then they filed this 25-page response this morning. Does anyone think Pam Bondi was up all night writing this? That's another reason I think this may have been orchestrated by the White House, the timing of all this. Trump obviously knew he was going to issue the EO on Friday. I'd like to think, and I suspect they were, smart enough to know, hey, when we issue this EO, we're going to have a lot of these TDA guys we have in custody running to the federal courts. Why don't, before we issue the EO, just imagine what their arguments are going to be and prepare our responses now, so we don't have to write them up after they go to court. The moment this hits, the moment the match is put to this gasoline, we'll already have our motions in place. I think that's what happened here. So afterward, the trial court issued an order certifying a class of individuals determined by the executive to be members of a designated FTO. These are every TDA person in the U.S., all non-citizens in U.S. custody who are subject to the executive order. That's every TDO person, and joins the government from removing members of that class from the nation, and sets a schedule for further discussing the TRO within the next couple of weeks. Argument from the White House. This court, the Court of Appeals, has jurisdiction to review the trial court's order. Although TROs are ordinarily not appealable, they are appealable when they are more akin to a preliminary injunctive relief. That is true here for two reasons. First, the order would work in extraordinary harm to the president's authority. Separation of powers doctrine violation. So the order would work in extraordinary harm to the president's authority to declare an invasion of the U.S. and his inherent Article II authority to repel such invasion and conduct foreign affairs. Courts have consistently held that the executive's determination of whether there is an invasion is non-justiciable political question, not subject to review by the courts. And the Supreme Court has long recognized that courts cannot issue an injunction purporting to supervise the president's performance of his duties, his core and plenary duties under the Article II executive branch of our Constitution. The president's discretion in this context and the court's lack of authority to hinder the exercise of that discretion is plain under the Alien Enemies Act. Quote, the authority of the president to promulgate by proclamation or public act the manner and degree of the restraint to which they, the alien enemies, shall be subject, and in what cases, is, of course, plenary, distinct and entirely within the scope of the executive, is, of course, plenary and not reviewable by the courts. This Court of Appeals similarly described the statute as conferring unreviewable power in the president. This Court of Appeals also has identified the significance of the harm that a TRO poses to the executive as a relevant factor in determining the TRO's appealability. Second, the injunction risks scuttling delicate international negotiations to remove dangerous alien enemies, and even a short delay in removal can frustrate removal, full stop. Furthermore, the district court has extended the potential harm nationwide. After scheduling an unusual emergency class certification hearing the same day of filing, the court ordered a nationwide provisional class certification and issued a universal TRO with no briefing by the government on either issue. Overreach, anybody? The trial court's actions strip away the executive of its key foreign affairs and national security authority oriented towards effectuating removal of alien enemies linked to a designated FTO, efforts that may be forever stymied if halted even temporarily. The Supreme Court has stressed that a trial court cannot shield its orders from appellate review merely by designating them as TROs rather than as appealable preliminary injunctions. And even if the order were unappealable, this Court of Appeals should exercise its discretion to treat this motion as a petition for writ of mandamus. So a writ of mandamus is an order from a higher level court to a lower level court telling them to do something, that you have the legal obligation to do this thing. You're just being obstinate. We're going to force you to meet your legal obligation, lesser court. So the White House is asking the Court of Appeals to simply issue an order to the trial court to strip away his TRO. The trial court's extraordinary order readily satisfies the standard to grant mandamus. First, if the trial court's order is not appealable, then there is no other adequate means for the White House to vindicate the president's authority under Article 2 of the Constitution to exercise the foreign affairs power of the U.S. Second, the White House's right to issuance of the writ is clear and indisputable. And finally, the writ is appropriate, indeed necessary, to protect our constitutional structure by safeguarding the president's prerogative against judicial intrusion. Again, separation of powers doctrine, violation. Section 2, the district court, the trial court, erred in issuing the TRO. The trial court abused its discretion in granting provisional class certification and TRO without allowing the White House sufficient time to respond to plaintiffs' motions. As an initial matter, the balance of harms weighs decisively in favor of the U.S. The trial court has enjoined the president from using his statutory and constitutional authority to address what he has identified as an invasion or predatory incursion. So it's not the war time trigger for the Alien Enemies Act. It's the invasion or predatory incursion trigger of the Alien Enemies Act. Invasion or predatory incursion by a group undertaking hostile actions and conducting irregular warfare. The TRO thus deeply intrudes into the core concerns of the executive branch. Again, separation of powers, doctrine, violation. The executive's authority in these areas, including sensitive and weighty interests of national security and foreign affairs, that, when subject to judicial review at all, warrants the utmost deference. The Supreme Court has warned of the danger of unwarranted judicial interference in the conduct of foreign policy. Moreover, effective, efficient removal of enemy aliens linked to an FTO when that opportunity is available is a key priority for the U.S. and avoids exposing U.S. residents to severe harm. TDA commits brutal crimes, including murders, kidnappings, extortions, and human, drug, and weapons trafficking. The Secretary of State's designation of TDA as an FTO represents the extraordinary finding that TDA is an organization that engages in terrorist activity that threatens the security of the United States nationals or the national security of the U.S. This Court of Appeals, to which Congress assigned the sole jurisdiction over the review of FTO designations, has emphasized its limited and extremely deferential review of the executive branch's role in protecting the nation and its citizenry from terrorism. And delayed removal may be removal denied. Removal operations entail delicate international negotiations, and those operations, once halted, have the significant potential of never resuming. On the other hand, as the Supreme Court has explained, although removal is a serious burden for many aliens, it's not categorically irreparable, as some courts have said. The Supreme Court reached that conclusion in a case where an alien argued he would face persecution if removed. A fortiori, an alien member of an FTO cannot fairly assert irreparable harm from removal from the United States. It is accordingly plain that the burden of removal alone cannot constitute the requisite irreparable injury, the irreparable injury that's a requirement of getting a TRO. Section 3, the government's likely to succeed on the merits of this AEA claim. So another requirement of getting a TRO is that the person asking for the injunction is likely to win on the merits. So here the White House is going to say, well, they're not likely to win on the merits. We're likely to win on the merits. So they lack yet another required element for an injunction. The White House writes, defendants, meaning the White House, are also likely to prevail on the underlying merits of these TDA's Five Guys challenge to the White House exercise of Alien Enemies Act authority. At the threshold, this case implicates questions outside the competence of the courts, questions only the political branches can resolve, because the courts are supposed to be apolitical. The determination of whether there has been an invasion or a predatory incursion, whether an organization is sufficiently linked to a foreign nation or government, or whether national security interests have otherwise been engaged so as to implicate the Alien Enemies Act, is fundamentally a political question to be answered by the president. Accordingly, no constitutional principle is violated by the lodgment in the president of the power to remove alien enemies without resort or recourse to the courts. Likewise, any threshold determinations the president must make before invoking the Alien Enemies Act are political judgments for which judges have neither technical competence nor official responsibility. And that's a quote from the Letica Supreme Court decision from 1948 that we looked at earlier. The sole question potentially open to review is whether the individual involved is or is not an alien enemy. But that is a claim sounding in habeas. And all habeas claims have been dismissed in this case and were outside the district court's jurisdiction, even if they had not been dismissed. Remember, these five guys, TDA guys, are being held in Texas. They're not being held in D.C. So if they were filing a habeas petition, they have to file it in Texas, which, by the way, their lawyers would know. So they knew it was BS to file the habeas petition in D.C. Continuing, in this case's current posture, there is no jurisdictional basis for a federal court's review of the president's executive order or any related determination. There can be no APA claim brought against the president's exercise of authority. And beyond that, no claim of agency action. Even if the executive order were reviewable at all, it is a proper exercise of the president's authority under the Alien Enemies Act and is reinforced by the president's inherent Article II authority to conduct foreign affairs and address urgent security threats and compelling immigration matters. First, the proclamation appropriately targets a foreign nation or government. The president has vast discretion in making such a determination, and the findings satisfy any proper review in this context. TDA's close and intimate connections with the Maduro regime and its infiltration of key elements of the Venezuelan state, including military and law enforcement entities, make it sufficiently tied to Venezuela so as to be within the scope of the Alien Enemies Act. TDA's growth itself can be attributed to promotion via the actions of Venezuela's vice president, and the Maduro's regime's connections to the group via the regime-sponsored narco-terrorism enterprise Cartel de los Soles are also clear. The Maduro regime coordinates with and relies on TDA to sow violence and discord throughout the United States. The president could properly find that given how significantly TDA has become entwined in the fabric of Venezuela's state structures, it is a de facto arm of the Maduro regime. It is the Venezuelan government. As an independent rationale, TDA also operates as a de facto government in the areas in which it operates. Venezuelan national and local authorities have ceded ever greater control over their territories to transnational criminal organizations, including TDA. In those geographic areas, TDA is in fact operating as a criminal government, independent or in place of the normal civil society and government. They've certainly taken over entire apartment complexes here in Denver. You got to pay your rent to them now. Rent goes to TDA, and they will come on rent day. Continuing. Given TDA's governance and organizational structure, as well as its de facto control over parts of Venezuela in which it operates with impunity as an effective governing authority unto itself, it would be well within the discretion of the president to determine it constitutes a foreign government for purposes of invoking Section 21, the Alien Enemies Act, the statutory form of it. Although the executive order's findings adequately justify its treatment of TDA as a government for purposes of the Alien Enemies Act, the U.S. has a long history of using war powers against non-state actors. Historically, the U.S. has authorized the use of force against slave traders, pirates, and Indian tribes. It has engaged militarily during broader armed conflicts with military opponents who had no formal connection to the state enemy, including during the Mexican-American War and the Spanish-American War. President Wilson famously sent more than 7,000 U.S. troops into Mexico to pursue Pancho Villa, the leader of a band of rebels opposed to the recognized Mexican government. While more recently, President Clinton authorized missile strikes on al-Qaeda targets in Africa and elsewhere. Military force is frequently invoked and used against non-state actors. Thus, even were TDA a non-state actor, rather than being intimately intertwined with the Maduro regime in Venezuela, the executive order is still valid under the AEA. Second, TDA is clearly perpetrating an invasion or a predatory incursion into the U.S. Although the definition of invasion obviously encapsulates a military entry, the accepted definition of that term is far broader. An invasion is an intrusion or unwelcome incursion of some kind, the hostile or forcible encroachment on another's rights, or the arrival somewhere of people or things who are not wanted there. And they cite the most famous legal dictionary here, Black's Law Dictionary. Nor is there any requirement that the purposes of the incursion be to possess or hold territory of the invaded country. Here, the actions of TDA fit accepted conceptions of what constitutes an invasion. Their illegal entry into and continued unlawful presence in the U.S. is an unwelcome intrusion of a foreign government-linked entity that additionally entails hostile acts contrary to the rights of U.S. citizens to be free from violence and criminality. Even if the actions of TDA did not fall within the broad definition of invasion, they still constitute a predatory incursion under the Alien Enemies Act. The phrase predatory incursion encompasses 1, an entry into the United States, for 2, purposes contrary to the interests or laws of the U.S. Here, TDA and its members have entered the U.S. for purposes contrary to the country's interests and laws, to engage in predatory activity under any meaning, illicit trafficking in controlled substances and people, committing violent crimes, and conducting business that benefits a foreign government antithetical to the United States. Those actions clearly constitute predatory incursions into the U.S. Beyond the statute, the TRO violates the president's inherent Article 2 authority. Again, a separation of powers doctrine violation. As a function of such authority to protect the nation, the president determined that TDA represents a significant risk to the U.S., that it is intertwined and advancing the interests of a foreign government in a manner antithetical to the interests of the U.S., and that its members should be summarily removed from this country as part of that threat. The exercise of authority in this case is firmly supported by long-standing Supreme Court precedent. As that Supreme Court has repeatedly held, Article 2 confers upon the president expansive authority over foreign affairs, national security, and immigration. And where, as here, the president acts pursuant to an express or implied authorization of Congress, which is what the Alien Enemies Act is, coupled with the president's own Article 2 powers over foreign affairs and national security, his authority is at its maximum. For it includes all that he possesses in his own right as the Article 2 president, plus all the foreign affairs, national security authority that Congress can delegate. If anything, this authority is heightened here. The Supreme Court has consistently noted that it is an accepted maxim of international law that every sovereign nation has the power, as inherent in sovereignty and essential to self-preservation, to forbid the entrance of foreigners within its dominions, or to admit them only in such cases and upon such conditions as it may see fit to prescribe. Part 4, the universal TRO is overbroad and unconstitutional. This Court of Appeals held in Citizens Protective League, rejecting the plaintiff's claims for injunctive relief against the Alien Enemies Act, that no constitutional principle is violated by the lodgment in the president of the power to remove alien enemies without resort or recourse to the courts. The courts have no role here. The Alien Enemies Act related jurisprudence, court decisions, limiting the courts to habeas review of AEA-related enforcement sharply contrasts with the universal TRO issued by the trial court over the members of the class, being every TDA gangster in America, with no habeas claims before it. So there's multiple layers of problems here. First of all, the White House is arguing correctly the only judicial review of an Alien Enemies Act decision by the president is whether the person being deported meets the conditions of the proclamation. Are they a member of TDA? Are they 14 years old? That's it. But whether or not they meet the conditions is a habeas issue for each individual. He has to be presented in court, and then the evidence of meeting those conditions is presented to the judge. But because it's a habeas decision, it has to be handled in the jurisdiction in which that person is being held. So in this case, that would be Texas, not DC. So this judge has no jurisdiction for the very limited review a court could even claim, because the people are out of this court's jurisdiction. In addition, they're arguing that the judge would, in any case, even if we imagine the judge had jurisdiction over these 5 people, it would only be jurisdiction over these 5 people before him, not every TDA member in the nation. The Alien Enemies Act precedent establishes that the role of the courts is only to assess whether a detainee is subject to the proclamation, not to probe the national security and foreign policy judgments of the president who issued the executive order. Moreover, while habeas jurisdiction must reach the custodian, the person who has the person who has the individual in custody, in detention, the warden of the prison, Here, this court issued a nationwide injunction where most, if not all, of the class members are beyond the court's jurisdiction. They're not in the District of Columbia. This sweeping order conflicts with the tight limits on habeas jurisdiction, the Alien Enemies Act precedent under which review of enforcement lies only in habeas, and the absence of any other jurisdictional authority. The highly truncated class procedures here were improper. In other words, the judge just did it within hours, decided there was a class of every TDA member in the nation. The highly truncated or accelerated class procedures here were improper, an excuse for the court to issue a universal injunction which is incompatible with foundational limits on equitable jurisdiction. The injunction undermines long-standing deference to the executive branch's national security judgments, including the president's responsibility to identify and respond to threats posed by TDA. Moreover, Article 3 of the Constitution, the judicial branch, does not empower federal courts to exercise general legal oversight of the legislative and executive branches. Again, a separation of powers doctrine violation. These are not normal parties in federal court. They are the branches of the U.S. Constitution. They get treated with more discretion. So it doesn't empower the federal courts. Article 3, judicial branch, part of the Constitution, does not empower federal courts to exercise general legal oversight over the Article 1 legislative branch or the Article 2 executive branch, much less empower the courts to assume a position of authority over the government acts of another co-equal branch, an authority which plainly courts do not possess. To the contrary, the courts have recognized the limitations of the judiciary in assessing national security information and judging the necessity of action to counter national security threats. Conclusion, this court of appeals should stay the trial court's order pending appeal and should immediately enter an administrative stay. To the extent the Court of Appeals harbors any doubt about its appellate jurisdiction, it should treat this appeal as a petition for a writ of mandamus. They're saying, even if you're going to say this is a TRO and you can't appeal TROs, we want you to just assert a writ of mandamus, just order the trial court to do as we wish, as you wish, and grant a writ directing the district court to vacate its orders, and then some just boilerplate stuff at the end, certificate of service, and that is that. I think that is pretty solid, if you ask me. Pretty solid work there. All right, I'm going to turn to comments now. So if you're, well, before I do that, hey, if you're watching this and you like this content, and we got a bunch of you here, 1,300 of you are still here an hour and a half in. Oh, let me fix this. 1,300 plus of you are still here an hour and a half in. Please hit that subscribe button. Hit that like, thumbs up. That's what tells the YouTube algorithm to share our content more broadly. And it's free for all of you. We're currently at, let's see. I can pull this up. 164,630 subscribers. My goal is 1 million. 1 million subscribers. I can't do that without your help. I cannot subscribe to my own channel a million times. Oh, it just went up by one. Thank you very much. So please like and subscribe. I'm going to turn to questions and comments now. If you're on YouTube and you want a question or comment addressed by me personally, it needs to be in the form of a super chat, a $5 minimum super chat. If you're a Law Self-Defense member, of course, I'll answer your questions for free in the member dashboard. Let me refresh this here. So go ahead. If you're on YouTube and you want to do a super chat, now would be the time. I'm going to answer the member questions first to give you a time to do that super chat thing. Let's see. Wow, there's a lot. Let's see. Up. Okay, here we go. Law self-defense member Wrestler Town says, I bet El Salvador would be fine with private citizens pitching in monetarily to buy the denizens of this prison extra years. If for some reason the U.S. wasn't going to cover the cost, maybe they could be. It would be it would be like one of those. Remember those things they used to advertise on TV? Maybe they still do. I don't watch TV anymore. I haven't in many years, but they used to have this thing on late night TV where you could sponsor a poor child in India or Africa or something. You'd send in, $5 a month and it would pay for that child's. It would pay for everything. It would pay for their clothing and their food and their education. Sponsor this lovely child. And we can do this. sponsor a TDA member in the El Salvador prison system, so we can keep clothing him and feeding him and educating him within the prison system. For $5 a month, we'll send you like a little ID card with his like biography. That'll be your personal prisoner that you're funding. Oh my God, that would be amazing. I might contact El Salvador and propose that. It's a business opportunity. Good Lord. Let's see. Mike says, isn't SCOTUS the only court that is a co-equal branch of government? Does POTUS have to abide by any inferior court? That's a good question, because I would argue no. I would question whether the Article 3 branch of government, the judicial branch, has any authority to enjoin the president in the exercise of his core and plenary executive powers. I think it's a separation of powers doctrine. The president doesn't get to tell the Supreme Court how to judge cases, right? The president doesn't get to tell Congress what laws to pass. So why would the Supreme Court get to tell the president when he can or cannot do something as the executive? I don't get it. But at best, I might imagine that the Supreme Court could claim that authority. I think they'd be wrong, but at least they were created by Article 3. I don't believe for a second that the inferior courts, the trial courts and the Court of Appeals, have the authority to enjoin the Article 2 executive branch president elected by the whole of the people to exercise their political will. Who elected that judge? Nobody. Let's see. Yes, the Article 3 judicial branch is supposed to be, it was written about in the Federalist Papers as the weakest branch. The weakest branch. Article 1, the sequence matters, folks. Article 1 is supposed to be the most powerful branch, Congress. They actually create law. Article 2 is less powerful. It's like a CEO. It's not the board. It's the CEO of the company. He executes the board's wishes, Congress's wishes. And then the judiciary, Article 3, is just supposed to settle disputes. Law self-defense member Paul says the only appeal to the TRO should be a direct letter to the trial judge who issued it saying F you. You know, it'd be funny. It would be funny if we did it like, oh my God, what was the Battle of the Bulge battle? I can't believe I'm blanking on this. Bastogne. President Trump should get a copy of that injunction and just write across it, nuts. To the federal trial judge, nuts. Commander of Article 2 branch of government. Let's see. Law self-defense member Mike says pretty soon these judges are going to be issuing injunctions on troop movements or drone strikes, right? The White House motion here for the stay mentions that kind of thing. Let's see. Law self-defense member Phil says, our last declared war was World War II. Declaration of war seems a passé notion of an earlier and more formal age. Yeah, that's true. We just don't declare war anymore. Let's see. Up. Okay, lots of discussion about who declared war on who in World War II. Law Self-Defense member Phil says, as these court actions continue, I'm increasingly disappointed, disgusted by the legal merits by the opposition, and increasingly impressed by Trump's White House and Department of Justice lawyers. Me too. Me too. I think the White House and DOJ are doing a fine job. They just need fair judges. Let's see. What else? What else here from the members? Law Self-Defense member Dirk says they should put that 3-minute movie of TDA going to the El Salvador prison as a trailer at the start of every movie in the US, Mexico, Canada movie theaters. Yeah, I think a lot of TDA will stop coming to America if it's perceived as a fast track to get to El Salvador. Get a free flight to El Salvador. All right, let me check out the super chats, and then we'll start to wrap things up here. Here we go. Let's see. Pat 76 $5 super chat says, if you get to 1 million subscribers, does that mean we have to pay $10 to ask a question? If I get to 1 million subscribers, I'll still need some way to prioritize the chat. There's thousands of chats. I need some way to pick out what are the questions. Matthew Felty, $5 super chat says, plan any coverage on SB 003 or working with Rocky Mountain gun owners. Is SB 003 that terrible gun law here in Colorado? I have to confess, I haven't really been paying attention because I'm moving out of the state. So I don't expect it to impact me very much. But it's those kind of gun control laws that are driving me out of Colorado. Rocky Mountain gun owners. So I knew the leadership there, but I think the leadership there left to form or to join some national level gun rights organization. I don't know that I know anybody there anymore. But they know me. I mean, if they want to ask me for help, they can contact me. I don't have a lot of free time. Content of character, $5 super chat says, I guess Nicolas Maduro will now start sending us 12-year-old TDA members so they don't qualify for the 14-year threshold. Yeah, the 14-year threshold is actually in the original 1798 Alien Enemies Act. Brandon, $5 super chat says, what are the prospects of us veteran security getting to apply for letters of marque to locate TDA? Well, we need more seats in Congress. MAGA needs more seats in Congress. Eric, $5 super chat says, out of the 3 appeal judges, 1 judge appointed by Bush, 1 by Trump, and 1 commie appointment by Barry. Okay, that's promising. I hadn't looked to see who the 3 judges were assigned. That's good to know. Content of character, $5 says, if Biden's handlers evoke the Alien Enemies Act, Biden would be a hero and AOC wouldn't cry. Right, of course. Jasmine Crockett would take victory laps. Jasmine Crockett. Oh my gosh. I've started taking some of her crazier videos and adding a smoke detector chirp sound effect in the background. I just think it's so funny listening to her talk with the chirp, chirp happening in the background. It's very funny. All right. A couple more. All right. Sending them in late. Whoops. I got an error message. Let me try that again. And content of character sent me another $5 super chat just to fix a typo. You didn't have to do that, man. I understood. Tommy, $10 super chat. Thank you very much. Right. So Trump's order is safe, right? Thanks for the splaining. And you're doing an important service, especially these days. Great show. Jetson tunes. Well, that's very kind of you, Tommy. I recognize it. Gadsden Jack, 386 British pounds. I guess that must be $5 US, right? Did President Trump just recognize TDA as a nation? No, he didn't recognize them as a nation, but he's arguing that they're acting with national effect, as if they were a nation. And I think that's everybody. Is that everybody? Yeah, the interesting question is whether or not, if it is a what was the distribution? Let's see. What did Eric say? A Bush, one Bush judge, one Trump judge, one Obama judge. It'll be interesting to see if the anti-Americans here, the lawyers representing the 5 TDA guys here, if they'll try to do a Hampton-Dellinger and realize they're going to get a bad outcome, so they'll try to drop the case to avoid the bad outcome. That didn't work for Hampton-Dellinger, but yeah, if it's 2 conservative judges to one Obama judge, I think this is locked in for President Trump. Let's see. All right, guys, I'm going to wrap up. It's been almost 2 hours again. Thank you for all your support. I couldn't do this without all of you. I think those of you on mobile devices may not be able to like and subscribe till you exit the show. So if that's the case, please do that. Please hit that like, thumbs up button and that subscribe button, where we picked up quite a few subscribers, but we need more. We're trying to get to 1 million, and it's free. And I appreciate all your support. So until we meet again, I'm sure we'll do 1 or 2 shows tomorrow on Monday. And tomorrow's St. Patty's Day, isn't it? I think it is. Well, I'll still be working. I'll still be wearing a tie. Until we meet again, folks, I remain Attorney Andrew Branca for the Law Self-Defense. Stay safe.